Good morning and welcome to the final estate planning seminar of 2022. If you've attended one of these in the past, you'll notice two new faces on screen today. I'm Justo Gonzalez, president of the Seattle Public Library Foundation, and I'm proud to be here with Duxun Huang, president of the King County Library System Foundation Board. We both felt it was important to come today to say thank you to everyone who shows up for these sessions. Since our Library Foundation started hosting these webinars in 2020, more than 4,200 of you have registered to attend. We also want you to know that many of you who use both of our library systems, we're just really grateful for you, and we're grateful to have you here with us today.
Thank you, Justo. I am Duxun Huang. Before we get started, I want to acknowledge the land that both of our libraries are on, the ancestral homelands of all tribes and bands of the Coast Salish peoples, including unceded territories. We honor with gratitude the land itself and thank the original caretakers who are still here and have lived here since time immemorial. We hope you will take this in and use library resources to study and understand this history, and then go forward in whatever way inspires you. Now, not only are there new faces on your screen today, but the format is different too. In the nearly 3 years of doing this, the one constant is that there is never enough time to get to everybody's questions. So today, we are throwing away the agenda and letting you all have the floor. Before we get started, I'm going to tell you a little about our foundations. As board presidents, we have heard over and over again just how important legacy gifts are to both of our libraries. Anyone who includes an estate gift to our libraries is invited to join Seattle Public Library Foundation's Library Legacy Society and or King County Library System Foundation's Literary Legends Society. We are glad you are here today to ask all the questions you have in mind. If you want to talk more about your estate plans, endowments, or other ideas, Cindy Schreck and Kara McDonald are here for you, and their contact information will be on screen at the end of the presentation. Thank you.
Now I have the pleasure of introducing our speakers, who I'll invite to join me on screen. Teresa Byers is an attorney with Ogden Murphy Wallace, where she focuses on trusts and estates, beginning with proactive estate planning to safeguard family members and wealth, and continuing to assist families in navigating transitions and implementing estate plans. Kathryn Haggitt Fisher is Chief Wealth Strategist at Fulcrum Capital. She has been providing philanthropic and financial planning services to clients for over 20 years, where she enjoys helping people understand and take control of their money. We're thrilled to have Teresa and Kathryn here today to answer your questions. Feel free to start populating that Q&A box.
Okay, thank you to our board presidents for being here with us today. I'm Kara with the Seattle Public Library Foundation. My colleague Cindy and I are always so happy to see you all here, and we are really excited to get started. But I want to remind everyone to please first put your questions in the Q&A box, not the chat, so that we make sure that our speakers see them. And also try to keep your questions as general and try to omit as many personal details about yourself as possible. This will just ensure that Teresa and Kathryn are going to be able to provide an answer and help you out. And if the questions are too specific, they just won't be able to get there. So thank you all. Let's get started. This is going to be fun. Okay, I'm going to get started with a question that came to us in advance. And this came from a library person who asked, what is the deal with probate? Is it terrible? Do I need to avoid it? What can you tell me about it?
Sure. So thanks so much for having me here today. I'm really hoping that this will be an opportunity for us to maybe dispel some myths and provide just a bit of information to ease people's process. And this is a great question to start with. So probate has become kind of a boogeyman. There's a concept that somehow avoiding the probate process is the most important thing that you can do in your planning. And that's not quite true. So all probate really is the process of changing title. If you think about, for instance, your house, once you pass away, someone needs to sign the deed to sell your house or to transfer it to the next person. And probate is the court supervised process to do that. Now, is probate awful? That really depends a lot on where you are located. So you go through probate in your state of primary domicile, as well as any state in which you own real property in your own name. So if you have a vacation home in Idaho or Maine, and that property is titled in your personal name, you're going to go through an ancillary probate in Washington, if that's your primary residence, or a primary probate in Washington as your primary residence, and an ancillary probate in that other state. Washington has an abbreviated probate process. We have what are called non-intervention probates. And that means in most cases, we can get a probate open with an electronic submission ex parte via the court without even a hearing. So it's a 24 to 48-hour process. It usually costs a couple of $1,000s to get through the entire process of probate, which is inclusive of giving notice to creditors and giving notices to all the beneficiaries. You have to do that whether you go through a formal probate or whether you use a trust as your primary estate planning vehicle. So the biggest savings in Washington around probate have to do with the complexity of the assets, some privacy concerns, and if you have out-of-state real property. That's not the case in all states. So for instance, going through property in California, Florida, or Hawaii is indeed a huge deal. It can be very, very time consuming and very, very expensive. So is probate the boogeyman? It depends on which state you're probating in and what assets you own. Okay, so looking at the next question that pops up on my screen, is a trust useful for those with less than 3 to 5 million in assets and a single child who will inherit all? I'm actually going to focus first on the first part of this question, which is a trust useful? And the thing to understand here is there's lots and lots of different kinds of trusts, and they do different things. There are trusts, like I mentioned a moment ago, where if you're looking to avoid probate, sometimes people will put assets into what's called a revocable trust or a living trust. And the sole purpose of that type of trust is probate avoidance. It doesn't do tax planning in and of itself. Then there are other types of trusts that are referred to as credit shelter trusts, bypass trusts, marital trusts. And the purpose of those types of trusts is generally to maximize your estate tax credits. So to allow, for instance, a married couple in Washington state to pass $4.4 million tax-free to their heirs. If they didn't do that type of marital tax trust planning, they would only be utilizing the exemption of one spouse, which is about $2,193,000 or $2.2 million per person. So there's tax planning trusts. So to this question, is a trust useful for those with less than 3 to 5 million in assets? If you have a married couple, a trust is useful to anyone with more than $2,193,000 in assets in Washington state. And then if you have a single child who will inherit, the question is, should that child be inheriting in a trust? Is that child in need of some assistance managing their assets? Does that child have special needs? Does that child need to qualify for government assistance? Are you concerned about that child's holding particular assets, a family legacy cabin or something like that, that might make a trust the right vehicle? So is a trust useful? Trusts are very useful. They're used for different things. Okay. The next question popping up on my screen is, what are the items to consider if parents have children with special needs when writing their will. Well, I'll speak to one piece of this, and then Kathryn, if you have some thoughts to add, I'd be interested to hear those as well on the money management side. But the quick answer from a legal perspective is if you have a special needs child who is qualifying for government assistance of some sort, those government assistance programs are generally income limited. Therefore, if a child with special needs were to inherit outright, they would receive too much in the way of assets to continue to qualify for government assistance. So most people, when they're thinking about special needs children and writing particular legal provisions into a will or a revocable living trust, they're thinking about writing in a special needs trust for a special needs child to allow them to continue to qualify for those government benefits and those government programs.
Yeah, and I would say on the investment side, think about who's going to be managing those investments and who's going to be the trust, more importantly, who's going to be the trustee on that trust, and who's going to be managing the investments on that trust. So thinking carefully about the experience that folks have, and the fiduciary responsibility of that. It's often helpful to have a professional who, both on the trust side and the investment management side, who do this on a regular basis. Family members may be willing to step up, but it can actually end up being a lot of work, and it's good to, I think it's worth, generally, depending on the amount in the trust, worth having somebody who really knows what they're doing help out with it. I'll move on. There's a question about long-term care versus self-insuring. So there's asset-based long-term care or hybrid policies, and then there are the traditional long-term care policies. So I'll get into that in a minute, but just sort of overarching, is it worth purchasing long-term care, or should I just self-insure with the assets that I have? A lot of that, the answer to that is it depends. I do have clients who have significant assets and could afford to self-insure, but they purchase the long-term care insurance because they don't want to spend, they would like to leave something to their kids, and they don't want to spend everything on their care in the last couple of years of their life. It generally can be a really good sort of thinking about it in terms of three legs to a stool, right? You've got the insurance to help cover some of the costs. You've got your assets and your savings to help cover some of the costs, and then Medicare and Social Security to help cover some of that. So it's just like the thinking about the rest of retirement. The hybrid policies are much more popular now than the traditional long-term care policies. And by hybrid, I mean, it's a hybrid of a long-term care policy and a life insurance policy. So the advantage to that is that if you don't need the money for long-term care, your heirs will get a life, essentially it's like, it works like a life insurance policy. If you do need the funds, they will reduce the proceeds that are available through the life insurance policy when you pass away. And it could be that you go through all of those funds, but if you don't, the money goes to your estate, so you don't just lose that money. They can be expensive. So that's part of the reason for approaching it from that three-legged stool. You may not purchase enough insurance to cover all of your insurance needs, but you just purchase enough to cover a portion of your insurance needs, and then the rest of it is self-insuring. So a lot of it depends on your situation, and a good planner or agent can help you figure out what the right answer is for you, and what the right, if it does look like a policy makes sense, what the right type of policy is for you. There's another question about adding up the value of your estate for the purposes of taxes. And I'll answer this because it kind of goes back to Teresa's discussion on probate. It's important to remember that there's your probate estate, and then there are assets that pass outside of your probate estate, which are usually things like your retirement plans, and insurance policies are kind of a gray area. But retirement plans like your IRA, your HSA often, your 401k, those pass according to the beneficiary designations. And in general, it's not a good idea to leave those to your estate, but sometimes that is appropriate. So it's important to work with a planner or your estate planning attorney. But in general, those pass outside of probate. So they don't pass according to what's in your will, they pass according to the beneficiary designation. They are, however, included in your taxable estate. So there's your, if you think about it kind of like a Venn diagram, there's your taxable estate, there's your, there's your taxable estate, and within that, there's your probate estate, and then there are any non-probate assets, but your taxable estate pretty much encompasses everything. So it's important to remember that, and it's important to make sure that those beneficiary designations are updated and accurate.
Yeah, and I'll just second that. I think it's confusing for a lot of people that they don't think about the fact that, frankly, most of us are worth more dead than alive because we don't access our life insurance and we're not pulling down the entirety of our 401k or our IRAs, but the full death benefit of your life insurance, the full fair market value of any of your retirement assets, any equity you hold in your home, anything in your bank accounts, any interests you own in a business, all of those are included in your estate for the purposes of calculating both federal estate taxes and Washington state estate taxes. And those estate tax systems operate independently of the income tax system, the federal income tax system. And those retirement assets are separately going to be subject to income taxes on any income tax deferred income, unless, of course, they're eligible for a deduction, such as the charitable deduction because they're passing to a charity, or they're eligible for a marital deduction because they're passing to a spouse. So please do remember that most of us are worth more dead than alive when thinking about this. It looks like there's another question related to trusts and wills. Specifically, do you need a trust and a will? Can you have just a trust? Can you have just a will? So you may have just a will, and that will may have within it what are called testamentary trusts, so trusts that spring into existence after your death. Separately, you may have a revocable living trust. If you have that, you also need a pour-over will. You never want just a standalone revocable living trust. And in Washington, it's actually malpractice for an attorney to draft a standalone revocable living trust without an associated pour-over will. And the reason for that's simple. It's because in order for a revocable living trust to work as intended, all of your assets have to be titled in the name of that trust during your lifetime. So every single asset you own has to be transferred into that trust during your lifetime in order for it to work as intended. Most people don't accomplish that task. Most people don't remember to title their car, for instance, or every single one of their bank accounts, things like that. People like to have their checking account in their own name. And so that pour-over will is the stopgap measure that picks up all of those other forgotten assets when you pass away and pushes them into the revocable trust. So you can either have just a will, or you can have a pour-over will and a revocable trust. On a related perhaps question, can't I just tell my kids, my spouse, my friends what I want and leave everything to one person and have them make it happen? No, you cannot. If you leave the assets to one person, that person is the sole heir. That person then can take the assets and do whatever they want with them. Moreover, in order to get them to someone else and effectuate their wishes, even if they had that intention, the person who inherited the assets from you would be treated as making a gift to those other individuals. And that gift has repercussions for that individual who inherited the assets. And so it's a really terrible idea from an enforcement perspective. And two, it's really unfair to ask a person who is inheriting from you to then turn around and engage in planning that will directly affect their own ability to do their individual planning. So please, please do not do that.
One caveat to Teresa's comment about the trusts and a pour-over will, or again, back to the retirement plans. It often is not a great outcome, or can result in not a bad outcome, but an outcome that's not very tax efficient if a retirement plan is left to a trust or an estate. That can be that it's appropriate, but you definitely want to check with your attorney when you're drafting those documents on how the beneficiary designation should be drafted for your retirement plans, especially if those retirement plans are large. You may want to handle those completely separately from the trust if you've got a revocable living trust set up.
Okay, so there's a question here specifically about how to choose executors, although I will broaden that a little bit and say this conversation will apply to fiduciaries. So whether you're choosing an executor, a trustee, or an agent under your power of attorney, who do you pick? How do you pay them? So a couple of things to know. All of those fiduciary roles have some statutory rules around them. And all of the statutes provide for the fiduciary, whether it's an executor, a trustee, or an agent under your power of attorney, to receive what's called reasonable compensation. So they are entitled to be paid, and they are entitled to be paid from the assets that they are managing. So an executor is paid from your estate assets, your probate estate assets. A trustee is paid from the trust, and an agent under a power of attorney is paid from your assets that that agent is managing. How do you pick someone to act in that role? Well, the first thing you do is you pick someone you trust absolutely, completely, and totally. So these are fiduciary roles. These people are taking on an obligation to act on behalf of someone else, and they're held to the highest fiduciary standards, which means if they screw up, they can be sued. So you want someone who's going to be able to handle that kind of pressure, is going to be responsive, is going to know to hire professionals to help them, is going to be a really good communicator. Most fiduciary disputes come out of bad communication. So someone becomes the executor or trustee and they don't want to communicate reliably, directly with the beneficiaries, or they get wrapped up in something else. And then people get scared because they don't understand what's going on. And that's the source of the vast majority of these disputes. So please pick someone that you think is a good communicator, someone who is able to keep track of things. If they can't balance their checkbook, they really shouldn't be acting in a fiduciary role, and able to hire help. This is not something that people should be necessarily doing at home with an Excel spreadsheet. You're going to want some professional help, whether it's legal help or accounting help or financial management help, to act in those roles. There are also professionals. So if you don't have someone in your personal life who's a good match for that, or you have existing conflict between your family members, it might be a really good idea to look at a professional fiduciary. Kathryn, do you have anything you want to add there?
Yeah, I would just say, even if you don't have existing conflict between family members, you might think about hiring a professional fiduciary if you have a lot of complex assets, or just a lot of different assets held in your estate. Maybe they're not that complicated, but there's a lot to keep track of. I have seen siblings who get along perfectly well end up having pretty serious arguments over the distribution of assets, over how it does. The process takes a while. Even in Washington State, probate can run, depending on how long it takes to liquidate assets. It can take a while, and other siblings start bugging about, where is this? What are you doing with it? And all of that kind of stuff. So especially if there are step siblings and there's a first marriage, or half siblings, or anything like that, set it up so that everybody keeps getting along, and just hire a professional advisor. It does cost a little bit more up front, but often in the long run, it saves a lot of money and heartache in the end. And that's, I'm not saying that you necessarily need it for every situation, but it is really worth seriously considering hiring somebody who's a professional and does it on a regular basis.
Okay, so there's a couple of questions related to real property. So residences, condos, things like that. So one of the questions is, can you donate a residence in your will and leave it to charities each 50-50? Yes, you can. Usually in that situation, the charities are not going to take the residents and own it 50-50. They don't usually have a use for that. So generally speaking, you'd want to include an instruction for the executor to sell the residents and then distribute the net proceeds 50-50 to the charities. And the reason you want to do that is because if there is an instruction to the executor to sell the residents, then there is a deduction that you can take for the costs of that sale as part of the estate income tax return or the estate tax return, depending on which one you take it on. But if you don't have that instruction and it simply goes out to the charities, then the charities have to make arrangements to do that themselves. And then there was another question about liquidating a residence and purchasing a new residence with someone else. Anytime that you co-own property with someone other than your spouse, I would strongly suggest that you have a co-tenancy agreement of some sort or a cohabitation agreement of some sort, something that outlines your ownership percentages as well as who's responsible for what expenses. State law considers some expenses like real property taxes and homeowners insurance to be what are called principal expenses. Whereas other things like maintenance on the property might be considered something that a tenant would be available to do and therefore more of an income use. And it's really important anytime you co-own property that you understand what your rights and obligations are going to be. If you don't have an agreement, the state will give one to you. There are co-tenancy laws, but if you're looking, for instance, to purchase a property and co-own it with someone and then be able to liquidate or access some of the equity in that home for other things, you're really going to want an agreement in place that allows you to do that, because otherwise your ability, for instance, to get a mortgage with your co-owner is going to be reduced, or for that co-owner to say, no, I'm not going to buy you out, or I'm not going to assist you in financing this property. Very rarely can you obtain a loan only against a portion of a property. So if you think about when you bought your home, your mortgage is secured by the entirety of your property and the bank has the ability to foreclose on that. So they're not going to be willing to loan money to one of two or three co-owners of a property. So anytime you co-own real property with someone, it's very important to have an agreement.
Yeah, and I would just, again, sort of tag on to that from experience I've seen with clients. Even if you think if it's a spouse, not a spouse, but a child or a parent that you're going to do this with, and you think, I don't really need that. It's just that we've got it all worked out. Get the agreement, have an agreement, sit down and figure out what you want. And there may be a little bit of discussion and disagreement while you're working on that agreement, but it's much better to get that done and get it all in writing so that down the line, when things come up and you're not agreeing, you can just fall back on the agreement and that settles the discussion. So it really is a good idea to get that agreement done and get that in writing.
So there's a couple people who apparently asked about estate taxes and who's liable for those estate taxes. So keeping in mind that estate taxes are applied on the whole of your estate, what's called your gross estate. So assets that pass through probate under your will and assets that pass by beneficiary designation. The answer is, unsurprisingly, it depends. If you don't say anything in your will, then the probate assets pay the percentage of taxes applicable to your probate estate. And the recipients of the non-probate assets need to cough up the taxes associated with those non-probate assets that they received. However, sometimes people will write a provision into their will specifically providing for their estate probate assets to pay the entirety of the estate taxes. And they do that because, for instance, when you pass IRAs or 401k or other assets that are income tax deferred, you trigger the deferred income taxes when you pull the money out to pay the estate taxes. So sometimes if you have the same beneficiaries for both your non-probate assets and your probate assets, you might elect to have all of the estate taxes paid from the probate asset chunk. but the state default is estate taxes are paid proportionately by the assets on the assets. And are assets that are donated to charities included in the total. Your gross estate includes all assets owned by you at the time of your death. It is a snapshot in time. So the entirety of your assets owned by you at the time of your death are disclosed on the estate tax returns, and then deductions are taken from there. So assets that pass to charities, qualifying charities, are eligible for what's called the charitable deduction. So there are no taxes paid on those assets, but they are reported on the return. And so there's a question about art, for instance, is that included in the gross estate? Yes, it is. Whether it's art that you created or art that someone else created, if you own it at the time of your death, it is included in your estate for the purposes of valuing the estate for estate tax purposes. And the value used is the value of those assets as of your date of death, or if you elect the alternate valuation date, the value of those assets 6 months later on the alternate valuation date. But in any event, those assets will be appraised and the date of death value used. And then if necessary, assets will be sold to pay the estate taxes, which are due 9 months after date of death for both federal and state estate taxes.
And one important option, if you are concerned about liquidity and not having, if most of the value in the estate is tied up in, for example, art, an insurance policy, a life insurance policy is one potential way to help cover those estate taxes for that. And I don't sell life insurance, so I'm not, but it can be a really useful tool for things like that. So that might be something that would be worth looking into is purchasing life insurance to cover the value of the art if you do in fact have a potential estate tax liability because of that.
So I'm seeing a couple of questions about foreign wills and foreign trusts. So keeping in mind, we have 50 states in the union, and each state has its own probate system and its own trust system. So there is no federal system. So if you move from another state into Washington state and you have executed a will or a trust in that other state, your will is still a valid will in Washington state as long as it was valid in the state in which it was executed. By the same token, your trust is still a valid trust in Washington state as long as it was a valid trust in the state in which it was executed. However, the execution of that will or that trust, if you're living in Washington, is going to happen in Washington. And so if you don't update your document, what you're asking someone in Washington to do is to go and, to the best of their ability, figure out what the state law is in that other state and try and effectuate the interpretation of the document using that other state's law while following the Washington state process. So my recommendation is always that people get their estate plan reviewed in the state in which they are planning to live and potentially die, because there are ways to make it much easier. Let me give you an example. So California has a very different probate system than Washington. It also allows for wills that Washington does not. So for instance, certain states allow for what are called holographic wills. So wills that are completely handwritten and only signed by the testator without witnesses. Washington state does not recognize a holographic will. So if you handwrite out, I would like everything to go to my spouse and children, signed Teresa Byers, and I do that in the state of Washington, that is not a valid will. If I do that, for instance, in California, and then I move to Washington, I now have a California holographic will that has to be admitted in Washington as a foreign will. Will it be valid? Potentially, yes. Will it be easy? Absolutely not. So please take the time to at least have your documents reviewed by a qualified planner. And if they tell you you should update them, pay attention to that. There's probably a good reason for it. If you are single with no dependents and have titled assets, how do you set up your estate to avoid probate? Well, whether you have no dependents or not, And whether you're single or not, there are two ways really to avoid probate if that's important to you. And as I said at the beginning of this, probate in Washington is not the boogeyman it is made out to be. So your first question should be, what do I want my plan to do? And do I need a probate process to do that? But the two primary ways to avoid probate are, one, to create a revocable living trust, as I spoke about at the beginning, and transfer all of your assets into that trust during your lifetime. If you do that, there are no assets held in your name at the time of your death to go through probate. The other way to do it is to very systematically and carefully convert all of your assets into pay on death, transfer on death, beneficiary designation type transfers. However, if you do that, you cannot do any of the spousal trust tax planning that I talked about as the second type of trust at the very beginning of this. So you need to be very, very careful to balance avoiding probate and the methodology you're using to avoid probate against your estate plan. I've seen a lot of estate plans that have failed because people got confused between probate and non-probate assets. So they wrote up a will, for instance, that did spousal tax planning, but then they got scared about probate. And so they transferred all of their accounts into what's called joint tenancy with right of survivorship with their spouse, or pay on death, or they updated all of their beneficiary designations to benefit their spouse directly. And there were no assets to pass under the will or through the revocable living trust. And so none of the tax planning trusts were funded. So people often get confused and they obviate their own good planning by trying to avoid probate. So please, please be careful if you're thinking of doing that.
There's a question about how do I find a lawyer who's optimized to my situation? And I think the best way is to ask other people who've done estate plans and ask them whom they worked with and if they thought it was a good experience. Certainly, if you have a financial planner or somebody in that that's in the attorney or financial world, ask around and ask for advice. The Estate Planning Council of Seattle, there's also an East Side Estate Planning Council, can be a good resource. They both have drop-down menus of their membership, and you can look up people in your location, in your area. You can read their bios and find their specialty, and you call them and just and ask them, set up time to talk with them and ask them. Often you can outline a little bit about your situation and they'll be able to tell you whether it's a good fit for them or not. Yeah, Teresa, do you have anything to add to that in terms of quality? I would definitely, for estate planning, look for somebody who primarily does estate planning, who lists that as one of the main things that they do. I would not have an attorney who kind of does a whole lot of different things do an estate plan, particularly if there is any complexity to the situation.
Yeah, what I always tell people is that picking an estate planner is a little like picking a therapist. They're going to ask you a bunch of really nosy questions. They're going to ask all about your assets in ways that you would never tell a normal person. They're going to pry into your family's, personal relationships and personal history if they're doing their job well. So if I'm doing my job well, I need to know what all your assets are. I need to tell you how to title all of those assets. If I'm doing my job well, I need to know what your priorities are. And I need to be able to build a plan around those priorities. And so take the time. Most estate planners don't call and be on the phone for an hour and ask the person to talk with you for an hour for free about the details of your plan. But ask them to take 10 or 15 minutes and talk to you and see if they feel like a good match. None of us are the right match for every person, and we should be conscientious of that. You might also ask some trusted either family members or friends who they've used. And if those people have kind of similar values to you, that might be a good person for you to talk to. But you should always feel like you can call your planner up and get your questions answered. And if you don't, that's a problem. Okay. There's a question about what is a credit shelter trust. And I'm going to again, answer this a little bit more generally, but a credit shelter trust or a bypass trust, as they're sometimes called, those are versions of the same thing. And the purpose of a credit shelter trust or a bypass trust is to assign an individual's estate tax exemption, so the amount that you can pass free of estate taxes, to a trust to allow that trust to grow over multiple transfers without paying estate taxes. So let me give you a little illustration. I happen to be married and I have 2 children. I have in the state of Washington, as a resident of the state of Washington, a $2,193,000 Washington state estate tax exemption, as does my husband. If I pass the entirety of my assets outright to my husband, and I wish this was true, but we're just going to use this for easy math, so bear with me. Let's just say that my husband and I, Washington being a community property state, have $4 million in assets, which means each of us have 2 million, right? It's community property state. I own 1/2, he owns 1/2. If I die and pass my 2 million to him, he now has $4 million. And then he dies. He has a $2,193,000 Washington state estate tax exclusion. We're going to use 2 million for easy math. So he dies, he applies his $2 million exclusion to the $4 million, and there's $2 million left upon which estate taxes are going to be paid to the state of Washington at a rate between 10 and 20%. A credit shelter trust or a bypass trust would be a trust that I create upon my death to put my 2 million of the $4 million in total assets in. So instead of passing my 2 million directly to my husband, I pass my $2 million to a credit shelter trust. My husband is the beneficiary of that trust during his lifetime. He can even be the trustee of that trust. However, when he dies, he does not own my $2 million credit shelter trust. Instead, it passes free of Washington state estate tax to our children or whoever else I've designated. He can pass his own $2 million to whoever he would like and whoever he designates in his will, but his $2 million exemption is there to shelter his own assets. So instead of paying somewhere in the neighborhood of $400,000 in Washington state estate tax when he passes away, we've completely avoided the Washington state estate tax. So a credit shelter trust or a bypass trust is a trust created usually between spouses or registered domestic partners as a way to maximize both spouses' estate tax exemptions.
And I like thinking of the term credit shelter. It's sheltering that credit, that estate tax credit that you get, that to close to 2.2 million at the state level and over 11 million at the federal level. It's sheltering that credit, which is why, hence the name, the credit shelter trust. I can answer the question on the payable on death forms. There are different terms for that. There's transfer on death. There's a designated beneficiary account. So it simply means that it's usually set up on either a checking account or a savings account. And you're the owner on the account, but at your death, that account, if you have a transfer on death or a designated beneficiary or a beneficiary designation on that account, it doesn't pass through probate. It would go straight to that person when you die. So it's somewhat similar to having a beneficiary designation on an IRA or a retirement plan. And BECU, this is the BECU didn't know what that was. So there may just be another term for it, but they should absolutely have that. It should be something that you can use. I would caution, be careful about setting that up. I've had several clients who had TOD accounts. They didn't even know, they'd forgotten about it and didn't even remember who the beneficiary was. So it's important to review that and make sure that if you do have that set up, that it works with your overall estate plan and that is in fact what you want to have happen with those assets.
Yeah, and just as a reminder, they're individual to each account. So you need to go through and update them as to each account, not just at each institution. I've had situations before where folks went in, for instance, updated what they thought were all of their accounts and then somehow missed one and had assets in that account passed to someone they had no intention of benefiting. And it's really important to keep in mind that just like we can't create a will for someone based upon what we understood was their intent, you actually have to have a formally signed will that is legal under state law. We can't transfer assets under a will that don't transfer under that will. So if you pull assets, whether it's via beneficiary designation or pay on death or joint tenancy with right of survivorship or some other way, so that they don't pass under your will, we don't have a way to get them back and pass them under your will. It's a really important piece of people doing their planning, and you should have a chart that you sit down and go through every single one of your assets and make sure that that asset is properly titled. If it has a pay on death or a beneficiary designation, that that beneficiary designation is correct. And you need to make sure you do it every time you move assets among financial institutions. And that's why I say it's important to have a good planner that you're not afraid to call up. But it's really critical. A lot of people will do a will a long time ago, or they'll do a self-help will, or they'll do something else with no real understanding of how those assets are going to pass. And that is the critical part of your plan. Okay. Do you need a will if you already have a revocable living trust? I think I answered this earlier. You need a pour over will. It's malpractice to have one and not have that. How do professional fiduciaries charge? There's two different ways. If you're working with a larger banking institution or trust company, they charge as a percentage of assets under management, and it depends a bit on the type of assets. So they charge differently for, say, a diversified portfolio than if they're active in a closely held family business. If you're working with a guardianship company, those also will act as professional fiduciaries, and they charge an hourly rate based upon the skill set of the person engaging in the activity. So if their accountant is working on filing the income tax returns, they're going to charge a different rate than the admin person who is doing bill pay and mailing. So you should just call and ask. The percentage of assets under management fees go down the more assets they have under management. So it's an inverse relationship.
There's a question about charitable giving through your estate, and do you recommend making charitable gifts as a % of the value or as a specific dollar amount? I think the answer is it really depends. There is an organization called Leave 10 that was started in the state of Washington that's encouraging people to leave 10% of their estate, which gets back to the original tithing of assets and income. That may or may not be appropriate. A lot depends on if there is something specific that you want to do, say at a university, you want to establish a lectureship or something along those lines. It is important to speak with that organization and figure out exactly how much you should give. Often people, you think about it in terms of the three buckets. There's your heirs, there's charity, and your heirs maybe not necessarily related, but anybody that you want to have inherit your assets, a charity as a different separate entity, and then estate taxes. So you can kind of shift assets around in those three buckets depending on what you want to have happen. I've actually had clients who said, you know what, I don't mind paying some estate taxes. I don't care if my estate has to do that. I don't want to do all of this maneuvering to try to avoid estate taxes. I'm just going to let it fall as it may. But it's good to understand what your estate might look like when you pass, so that you can make a conscious decision about that. But so back to that question of a percentage of your estate or a specific dollar amount, it really depends. And that's why, back to what Teresa said about a good attorney who will ask you a lot of questions, and they'll get pretty nosy and help you understand what your concerns are about your family, what's important to you, what you want to support. And a good estate planning attorney can help you figure that out. And then a good financial planner can help you figure out what might be the value of your estate if you live a full life, and what would that value be going to charity, and can help you figure figure out the answer to that question.
Yeah, and keep in mind, you can do a greater than, less than. It's kind of like a math story problem. So I can say, for instance, if my estate is greater than $3 million, then I want X, the larger of X percent or X dollar amount to go to so-and-so. So you can set it up as a logic problem if you're concerned that your estate may vary or fluctuate pretty wildly. And so keep that in mind too. When you work with your planner, explain what you're trying to make happen, and they can probably draft something to that. Let's see. Washington state and federal estate tax. I'm just going to talk about this really briefly because I think it's an important thing to understand. The federal estate tax system operates completely independently from the Washington state estate tax system. Washington state does not have portability. You cannot claim your spouse's exemption. It must be assigned to a trust or it goes away. The federal government does allow you to do what's called porting of an exemption, but in order to port an exemption, you must file a federal estate tax return, a Form 706. So you're probably not going to see specific language in a will or a trust about portability. What you're going to see is language providing the executor or trustee with options allowing them to make the most tax efficient elections at that time. If you have a credit shelter trust or a bypass trust for the purposes of assigning the Washington state estate tax credit, you should see that language in your trust or will. If you don't have it. So it's just an important thing to recognize. But Washington state does not have portability. So there is no option to claim your spouse's exemption in Washington. Let's see.
There's a question. Can you explain how 529 college plans can be used for estate planning? They can help facilitate getting assets out of your estate. It is possible to, most of the plans will have limits to the amount that you can put into the 529 plan. Generally, you can gift into the 529 plan. Each year you can gift up to the annual exemption amount, which this year is some 17,000. So is it 17,000 for 23, Teresa?
It'll be 17,000 for 23. Then you can hyperfund.
Yes.
Oh.
So you can, so if you're a married couple and you have, say, a grandchild, you can put 34,000 because you can each gift to that grandchild. And then you can bunch your funding up in the first year and elect to spread it out over 5 years. So you could get, if you're giving you want to give 17,000 a year over 5 years, you can do that all at once in 1 year. And you just file a gift form saying that you're electing to spread that out over the course of 5 years. So that can be a really good way to get a good chunk of money out of your estate and gifted to kids. And you can't guarantee that it would be used to pay for college, but there are penalties if you use those funds for anything other than educational expenses. And that actually includes high school. You can use some of it for high school now, but that can help you maintain a little bit of control. You're really encouraging them and making it clear you expect that to be used for college. So that's one way to get some assets out of your estate. And again, it allows you to do that giving all at once, which is really the best way to take advantage of the tax benefits of a 529 plan. And the real benefit to a 529 plan is that tax deferred growth. So if you're bunching 5 years of gifts into that in the first year and the child is only a year old, there's a long time for those assets to grow tax deferred.
Okay, so there's a question here. What are the basics for a married couple with children under the age of 18? So minor children. And I'm just picking this up because we're talking about 529 accounts. So keeping in mind that 529 accounts are something you actually transfer out of your estate. So they're not included in your estate for estate tax purposes when they're for the benefit of someone else. If you are looking to plan for minor children, the first thing to know is you want to name a guardian. You want to nominate a guardian. That person's only going to act after a guardianship process has been initiated, but the nomination is very important because the court does give deference to that. So you're selecting the individual who's going to be responsible both for the physical custody of that minor child, as well as for managing their direct assets. So not assets that you put in trust for them, but direct assets. Because if you pass away while you have a minor child, Social Security pays out every month a Social Security benefit, and it's not insignificant. We're talking often, $3,000 to $4,000 to $5,000 a month that is used for the support of that child. You also need to create a trust for that child. If you do not create a trust in your estate plan for the child, the state of Washington will provide you with a trust. It's called the Uniform Gift to Minors Act, a custodial account. The state will actually require the funds to be invested until the child is either 18, 21, or 25, and will appoint a effective custodian or trustee for that account. The vast majority of us would prefer to name our own trustees for our children's accounts and have that trustee follow our investment plans as opposed to the state of Washington. So I highly recommend that you do that. You should also think a little bit about what the terms of that trust for your children should be. What are your values? We each have our own sets of values. I'm not generally worried about children not having enough for food and clothing and a place to live. But maybe you have remote family and it's important that the trust be able to pay for the children to go visit that family in another place. Or maybe it's important to you that your child have a particular type of schooling or a particular religious upbringing, and you need to include in the trust methodologies to facilitate that. Whether it be a private education or a bar mitzvah or paying for a wedding or whatever it is. And again, a good planner should help you talk through your family values and incorporate as appropriate those family values into your plan.
Well, it is almost 11 and it's time to wrap up. I do have one last question for you. Can you explain how a charitable remainder trust works so that assets pass to charity after an expiration?
Yeah, so charitable remainder trust is exactly what it sounds like. It is a standalone trust that you set up. You gift assets into that trust throughout either your lifetime or the lifetime of the beneficiary or a term of years you set up. That trust pays out a set percentage to a designated beneficiary. And then at the end of that term, however that term was defined by you when you created the trust, whatever is left in the trust, the remainder, goes to a charitable institution that you've designated, a qualified charitable institution that you've designated. When you do that, when you make that gift to the charitable remainder trust, we run a very fancy calculation to determine what the charitable remainder is, and you get a charitable deduction for that. And you can either set these up during your lifetime, or you can create one in your estate plan to be set up upon your death. So it would actually, for instance, I could set up a charitable remainder trust that said, when I die, my life insurance proceeds go into a trust. They benefit my 2 children for 10 years. And at the end of 10 years, they go to the King County Library System Foundation. That would be a typical charitable remainder trust.
Thank you, Teresa. I am Cindy Sherrick from the KCLS Foundation. I want to thank you all for asking such great questions, over 100 questions, my goodness, and for your patience as we experimented with this new format for our webinar. Be sure to let us know what you thought about this webinar in the survey that's going to pop up when you exit. Everyone who finishes that survey is entered into a raffle to win a bag of books, our favorite. So again, our sincere thanks to our incredible speakers, Kathryn and Teresa, for taking time out of their schedules to share this important information and ideas. And I hope you all have found it valuable. And like I said, we'll be sending out a follow-up email with a recording of today's session, additional information. So please look for that later this week.
And we hope you learned a lot today. I know it came fast and furious, but we will send that recording so you can rewatch this and take notes. And there are ways to download transcripts as well. But with all that in mind, I hope you'll also know that a charitable bequest is one of the most meaningful ways that you can support your libraries. Please let Cindy or me know if you're interested in learning more, or even if you are including us in your plans. We would love to say thank you in person while you're still with us and add you to our estate planning societies. And if you ever have questions or want to continue the conversation about what you heard today, you can always contact Cindy or me. Our contact information will be on the screen shortly. Thank you all so much for coming today, for all the amazing questions. And remember, it is year-end giving season. So if you haven't made a gift to support your libraries this year, please do consider that before we start 2023. Thank you all again for being here, and take care.
Thank you. Are we staying?